Bring a
Get
chair.
you a chair to the front row.
You can put it right here.
Jump on up here. Jump on up here.
Yeah, swap.
But we can put them right there at the end. Right where the camera goes in.
Jeff gets like a triangle ring as the man to see the front table.
We could get like a kid's chair and put it right here.
Let us know when you're ready.
We're ready. You're ready.
All right, Bernard, we're ready. We on? All right. Good morning and welcome to everybody. So we are prepared to go forward and would like to engage with y'all in a fairly intense bargaining. As you know, we have scheduled dates for next week. We have these discussions today. Our city manager would very much like for us to do our best to put this contract together and reach an agreement as quickly as possible if that's feasible. And that's what we want to talk about today in short order if we can. And we're serious about doing that, spend the time and energy and address the issues head on, make the hard choices and see what we can do. What we're showing you today, I think, is really kind of the segue to explore the feasibility of accomplishing that objective or plan. This proposal, which we have set aside here as new language for Section 3, and we'll go over in a minute the red line of the entire article, but it's important in the context of prior discussions where y'all have inquired about whether or not taking the Office of Police Oversight out of the contract is a line in the sand and so forth. We don't think it's necessary to have a line in the sand discussion. We believe that the interest-based approach that we've used in the past allows us to focus on how we can resolve the issues that we both need. I want to do my best to lay out clearly what our vision is. We think it's consistent with what the community's expectations are. We think it's consistent with the interests and the needs of your membership, that it is a fair approach, that it's consistent with the culture of the city of Austin, the expectations of its citizens. So this article starts out with the parts that we are required to bargain in the contract and that we couldn't do without that because of the baseline 143 provisions that we can only change if we reach an agreement. And then we understand that to the extent that we are going to not include all of the particulars and the details and the processes and so forth for LPO, that your members are going to expect to know what that looks like. We are defining the items and where they will be set up by ordinance or by policy, because answers to those questions are essential. The ordinance is being drafted based on the logic that you will see today as I go through the process. And so those are the essential assurances about the boundaries for OPO action. And so I think in the context, I really do need to allude to, one of the realities that is the prior arbitration award on this controversy between the association and the city in the past. And my observation, trying to be objective, even though I'm on the city side as our representative, is that there are both rational and emotional aspects of that arbitration award. There are disagreements in terms of what we think is right or wrong about it. It is the reality of what happened in the past, and it has created a lot of the community responses and reactions. It's responsible for the positions and understanding that your members have. And so the reality of that context, I think, is important. We believe that what we're putting on the table today is a balanced and optimum approach. We are willing to discuss with you limitations on what OPO can do. Our baseline understanding and belief in Texas law is that police officers are entitled to come to the table and bargain for due process and job protections. The city of Austin has always been committed to the top level, best there is, equal or better than other city governments in terms of due process protections for police officers, quality of investigations, objective measures, the right to appeal to independent third-party determinations. We fully understand and support, and the city manager fully understands and supports that level of protection for police officers in this community. This is a community that imposes high levels of expectations on its police officers. The men and women that join this department, the men and women that have stayed with this department during the difficult and trying years in the immediate past, are people that are committed to the absolute best level of policing that exists in the state and in the United States. The city manager knows that, he believes in that, and that's why we are trying to make this arrangement. On the other hand, we don't believe that the public should have to come to the bargaining table and ask for permission to have oversight for the police department, because the police department functions under the authority and the prerogatives of the city manager. The city manager also authorized me to tell you that he is committed to understanding and making sure and keeping his eye on the ball for this function as we go forward. We will talk about that some more. It's entirely possible that he'll come here and talk to you about that himself. That's what the purpose of the ordinance and the policy and so forth is. And I believe that this process will not result in the repeat of the disagreement that happened during the term of the current contract. But we would like to make a new contract. There are pay and benefits reasons as well as just stability reasons for accomplishing that in the short term. So the items in B are authorizations, because we need to authorize these things by agreement in order to set those aside from the 143 provisions that would otherwise apply. Number one, to accept anonymous complaints as defined in this article, to publicly release at the Office of Police Oversight's discretion recommendations made by the director to the chief about the classification of alleged misconduct, whether or not an independent investigation is warranted, disciplinary action to be taken, and any reports pertaining to the above. Third, the release of information otherwise made confidential by section 143-089G to a complaint in a closeout meeting. Many of those closeout meetings will involve a sustained complaint, in which event there's not an issue because that information is public under the statute. But to the extent that there are non-sustained complaints, the closeout meeting, really to be effective and to engage public confidence in the process and the system, needs to have some discussion of the underlying facts, and so we've included that as well. We've added to that, it's expressly understood and agreed that any release may contain information otherwise would be made confidential by that section of the code. C is the two items that we think are the cornerstones of your members' expectations about what the limits are on the Office of Police Oversight. Number one, that they do not have direct subpoena authority over members of the department, and secondarily, that they will have no disciplinary authority. And so what we are saying here is the ordinance and the policy of the city, exercising the city manager's prerogatives under the charter to provide oversight over the police department, is not going to change those two things. Won't surprise me if you have some other items that you want us to talk about and consider under C. We think those are the cornerstones. We think most of the rest of those issues are in the details. We have added to this, after our discussions that I've alluded to with Manager Cronk, quarterly meetings so that we can make sure that your leadership on behalf of your members can sync up with expectations and open communications with the Assistant City Manager for Public Safety to make sure that the manager is in the loop, that everybody has an opportunity to talk about what's going on, whether or not it's necessary, appropriate, and needed, and that you have that place at the table for feedback to the manager, and adding to that for an annual meeting directly with the city manager on the way this process plays out. Frankly, I think that those two things, had they been done effectively in the past, would have had the potential to eliminate the problem. You may disagree with that. I may just be totally wrong, but I do have confidence that this is a process that can work if we continue to have the collaborative relationship that we've had in the past. So I want to walk through next the flow chart for how this will play out, and you will see when this comes up on the screen that part of what we are emphasizing here, both for your members and the community, is the limited nature of the contract provisions that we are talking about in this process. This is, in many respects, the process that you have been historically familiar with. The item in blue there on the first slide is the only part of this list that would be in the contract. We've just gone over that in our proposed Section 3 language. Under information obtained, we have the personal information, nature of the complaint, witness information, incident location, date and time, and the APD officers involved. I'll use that just as an example because I'm inviting each of you, as you look at this and consider it, to think through, okay, what is it about that if it's in an ordinance or it changes a little bit or there's a definition about the nature of complaint, that the ordinance gets modified after input from the public, that has any potential to interfere with or adversely affect the members of your department in the disciplinary process? Because I think that there's just nearly none. And so all of the minutia of the way this process works doesn't have to be in this labor agreement for it to work well, for it to serve the public in terms of providing information that leads them to understand and believe that police performance is evaluated, that police discipline in terms of compliance with rules and regulations is taken seriously, objectively determined, and enforced by the chief. Because under this system, there is no discipline except by the chief of police. Preliminary review. The Office of Police Oversight may perform an initial assessment or determination of whether to forward to IA. They can ask for more detail or clarification from a complainant to decide whether or not that is true. Once again, I believe that that is a process that is not a threat to the legitimate interests of your members in the face of the due process protections. And I'm going to talk about that later. I'll just mention at this point, kind of as an asterisk, we've gone back and looked at all of the major labor agreements in this state, many of whom, as you already know, Mr. Delord and I have been involved with. El Paso and Dallas and Fort Worth and Houston and so forth and so on. We believe that the officer rights protections in this contract are the best in the state of Texas. They are equal to or better than others. If there are others out there in those contracts or others that you know of that you think we should talk about and consider, we are wide open to talking about that. Because nobody is trying to take away in the OPO process the ability of officers to rely on and count on the fact that their conduct is going to be objectively evaluated, that the police chief is going to make a decision free from outside influence and the pressures of a particular incident or the day or the environment or the culture at that point in time, and that year to year under this contract, the discipline is going to be based on the same standard and the same consistency. So, recommendation is the next slide. Recommendation to internal affairs that a complaint be investigated, and a recommendation for classification of the complaint. Then under the appeal of the recommendation, the OPO can make a direct appeal to the chief of police if the complaint is not classified correctly according to, in other words, if the OPO says that's not the right way to classify it, then that can go to the chief who makes the final decision. And a written report of deviations from OPO recommendations would go quarterly to the city manager. Once again, we believe if you'll just take each of these things as a standalone proposition and ask yourself, isn't the city manager already authorized to do that? Because we believe that the city manager is authorized to do those things. And that the city manager has not only the prerogative, but the responsibility to know whether these things are being done correctly by his or her chief of police.
And can I just jump in on this, on the previous slide, so we have to back up a second? So if you look at how it currently works under the contract, this is more to show you what we're asking for in the contract in blue. What is in gray, 99% of it is already true, but I just want to point out changes that we're making kind of as we go along, what we would envision would happen that is different from what you have in the contract today, regardless of where the authority comes from. So the first thing is, obviously in the arbitration decision, there was some question over whether or not and how OPO was clarifying complaints and whether or not to turn them over. And we'll go over through how that is in the investigation process slide, but that's a touch different there. And the other thing is the actual appeal of the recommendation. Currently that's true, but it's not written down anywhere. So currently if OPO disagrees with IA's classification, they do appeal directly to the chief, but that's not written anywhere. So that would be the separate change from that.
And once again, we're developing the ordinance that captures those items and fully expect to have your members be able to look at both of those sources and say, this is the way this process is going to work. We're not proposing a substantial amount of change. We are trying to focus here on the changes that we are proposing and to make sure that we can sort through those and try to come to a consensus about them.
Correct.
So the next slide is this Office of Police Oversight, what is made public, the nature of the complaint, the recommendation for classification. All of these things would be in the ordinance. Now, some of these things here, like what is not made public, they're already driven by the state law provisions we talked about a minute ago. They are defined, as we talked about in the proposed section 3, about what is not made public. Well, the statute, if it's not made public under the agreement in the contract, then it's not made public. The ordinance will explain all of that. It will be more comprehensive. It will include parts that are bound by the contract, but the other items are not bound by the contract.
And this is all no change.
This is all no change from existing practice. The only change is the difference in the structure. that it will be in the ordinance.
When do we anticipate y'all having the ordinance ready?
We are busting it to get the ordinance done. It is being written, we've been working on that during the last 10 days. I wish I could give you a commitment on the time, but as soon as we can do that, we will do it.
Fair enough, thank you.
Fair
Before we
question.
ask you to approve this, let's be clear on
Absolutely.
that. We know that you're gonna want to see
Right.
what we need.
Yeah, and that's what I meant a minute ago when I said, we know your members are gonna expect to be able to see, okay, what's in the contract, what's in the ordinance? And have the conversation about how can I rely on the ordinance and why should I? Because that's what we need to talk about. Investigations is the next slide. You see, once again, the blue highlights here show the limited things that are in the proposed labor agreement as we have brought it to you. That we return to 143 for the definition of an investigator. Chapter 143, and this may surprise you, even though the culture and the arrangements here in the past have been that investigations are limited to internal affairs individuals in the police department. Chapter 143 allows an investigator to be on behalf of the municipality, not limiting it to the chief or his subordinates, not limiting it to internal affairs or to the department. The OPO under this model, per the ordinance provisions being drafted, would have the right to require additional witnesses to be interviewed. The OPO would have the right to be present during all witness interviews, and the OPO would have the right, under this proposed ordinance, to question all of the witnesses. So this means that we have a process where an internal affairs investigator is going to be assigned the file, is going to be going through the allegations, determining what to ask of witnesses that are not subject officers, determining what to ask of the subject officers. But at the same time, instead of asking for permission to ask a question, the OPO would be able to ask the questions. At the end of the day, the answers to those questions, from my perspective, are just facts. They are facts that the OPO solicits that they believe need to be asked. They need to be in the file. The chief needs to be able to consider them. But the choice of whether or not the facts matter and whether or not the facts constitute a violation of rules and regulations is still solely in the hands of the chief. The OPO can recommend classification change and appeal directly to the chief if a recommendation is not changed, and then that would be included in a quarterly report. Once again, this assures the citizens of this community that somebody that's not a police officer, somebody that's not wearing a badge and a uniform, is going to be thinking about which facts matter here. What questions haven't historically been answered? People that don't trust the process, that believe that the questions are softballs, that the hard questions don't get asked, have this assurance that this investigation is going to be complete. This is only about having it complete, because the chief is still going to determine whether or not any of those facts establish a violation or not. And then obviously, the same appeal to an independent outside third party with due process on both sides to determine whether or not those questions make a difference or not. Limitations would be in the contract, and those are the two items I've already mentioned. No subpoena power, no disciplinary authority. And I think you understand the structure. The next slide shows the Office of Police Oversight. Once again, I believe this slide also is no change from current practice, is that right?
No, there is a change from current practice.
Which one is that?
So right now, both OPO and IA get kicked out during the chain of command
Yes,
meeting.
exactly.
And under this structure, the OPO would remain during that meeting.
Right. So, under the meetings, the Office of Police Oversight can attend any DRH meeting conducted to determine whether disciplinary action is taken against an officer. And that change is in the second block, proposed to be in the ordinance and being drafted as the draft that we'll be presenting to you, is that they may remain during the discussion of final classification. This addresses the concern that ultimately the the decision is made in isolation with only police officers and without the perspective of the outside individuals in the police and the OPO. Again, from our perspective, what this means is the city manager, who's the boss of the police chief, has the city manager's delegate in the room to make sure that their perspective, which may be different than the IA and command staff, is in front of the chief before the chief makes the final decisions.
Well, and let me just point out the "or" in
Or.
that section. Or they may have a separate meeting with the chief of police. And from the community perspective, that's along the lines of somebody in the chain of command is this guy's buddy. He's protecting him, he's doing this or that. Whether or not that ever happens or not, there's the potential for the OPO to have a separate meeting outside of the chain of command meeting with the chief, so that they can express those concerns to the chief and say, hey, you may not be aware of this, but. And I think that's one of the big community concerns, and it just allows for that option, whether or not it ever happens or not, the option's there.
Well, and let me just comment on that, because in my history of about 40 years of doing this for city governments around the state, I haven't just seen members of the community that had that concern. I've seen quite a few internal affairs complaints or statements from officers in the course of disciplinary investigations that come from people wearing the badge, about how somebody else is not being treated right, about how that person was a buddy of this AC or that AC or whatever, and the disciplinary process wasn't fair. So that's not just a community or a citizen concern. And you know, you're probably aware, just like I am, of situations like that where officers have initiated complaints about that level of unfairness. The association in its representation of your own members comes forward to these appeal hearings and says, we have inconsistencies in the way discipline has been imposed. And so this officer ended up with a substantially greater suspension or got terminated, where somebody else just got a few days off. So that's another, I guess, example of why we think that is an entirely legitimate process. Once again, this is only input and a recommendation of a potentially different perspective to the police chief to make a final decision. And statistically, looking backward, many times, most of the time, and I think way more than most of the time, there actually wasn't a difference of opinion in those cases. Under the recommendations, the OPO may submit a separate recommendation to the chief on final classification, and as indicated, final decision is with the chief of police. And actually, that one should be blue, because it's encompassed within our guarantee. Just inherently.
Yeah, I mean, we are absolutely, you know, there is no chance in the world that any ordinance that's crafted, and the reason we put guarantees in here is because even though you see the ordinance, you know that city council in a year or 2 years, whatever, can change how that OPO ordinance looks. So the reason we're trying to put guarantees in here is so that we're never gonna take that away from the chief. We are stating right here, the chief is gonna be the decision maker. We're not going to have someone else making that decision. We're not going to grant subpoena power during the term of the contract. That's a guarantee. So those, when we say guarantees in the contract, and as we said, we're willing to listen. If you have guarantees that you think should be there, we're willing to listen. But yeah, that should be blue. That's something that we're willing to guarantee is the final decision will remain with the chief of police.
So we come to the next slide here, showing the disciplinary stage. These are both items that will be in the section 3 that, as we have proposed it to you. And you know, I will kind of harken back to the presentation, my earnest and impassioned plea to y'all, where I pointed out to you that by far most of the individuals that take the oath and wear the badge and go out there to serve and protect their communities in the state of Texas don't have any such thing as a G file. They have a personnel file that is a public record and open to the public for a request from anybody. I explained that to y'all. I told you that in my experience in hundreds and hundreds and hundreds of cases, I've seen very few of the kinds of incidents that create problems that your members are worried about in terms of release of G-file material. And I asked you then, and it was the city's proposal then, that you agree with us to eliminate the G-file limitations on transparency and access to officers' files. We haven't got anywhere on that. Apparently I had no takers that day. So what we're proposing to do here, if the screen will come back on, oh, thank you. Good work. We are modifying that proposal to be the release of G-file material on all critical incidents, regardless of whether discipline is rendered. We've tried to figure out how to do this. There was a lot of internal discussion about this. I believe, and have made this speech to y'all before when we negotiated the current contract, that the sooner that information is released to the public, the more the public will have confidence in the process, what the officers did on the street, or the response of the department and the chief of police if mistakes were made or if misconduct, deliberate or otherwise, actually occurred. We think that's a reasonable place to draw the line. It means that to the extent that your members don't want the kinds of stacked complaints that happen, against police officers. The argument's been made here at this table before. I've heard Mr. Delord here eloquently talk about how if somebody has a really bad beat, a really bad shift, and a really bad place, they've got a whole lot more incidents, they have a whole lot more arrests, they have a whole lot more occasions where they have to use force or make choices that may be second guessed. And so, looks like they're a bad officer, man or woman, and that's not fair. And so, we believe that limiting this to critical incidents is an appropriate place to draw a line, demonstrating to the public that we want them to have access to the material that's most important, that would suggest or actually represent the most serious forms of misconduct. Release of the G-file material contained within the OPO recommendations to the chief, and those are right out of the Section 3 that we started out with. The classification of misconduct, whether an independent investigation is warranted, disciplinary action to be taken, and any reports pertaining to the above, plus the closeout meeting, which we listed earlier. And I believe A, B, C, and D are current practice and current contract line.
Yes.
No change in those.
Correct.
And we've added the closeout meeting because of the fact that there is the potential for, or the actuality of some of the information that would be in the investigative file being disclosed in the closeout meeting. Any comment on that one before I move on to the next one?
That's actually already true too. It's just that because it's 143, it needed to be included.
Yes. Yes, current practice, but this is just a caution. All right. Success and issue meetings. I had alluded to the purpose of this before, so that's already been stated. There's currently a quarterly meeting with the director of the OPO, the chief, IA, and the APA president. And so we're proposing to add the ACM over public safety to this meeting so that there is a structural participation and awareness of the manager's office and how it's working. And in my conversations with Manager Cronk, he made it clear to me that he wants this to work right. He's going to pay attention to it. His subordinates are going to keep him informed. And he believes that we can avoid the differences of opinion and the conflicts and the problems that have happened in the past. In the annual meeting, we've added that to give direct access to the city manager to discuss how this works, the issues and successes. And this is part of the assurance to your members that by doing this in an ordinance as opposed to a contract negotiation, the items we've shown here in the grayscale are a realistic part of the process for the city to control and manage under the manager's authority, and that he is directly going to be exercising that authority and oversight.
And before we go to the next slide, can we go back to slide 5 for just a minute? Because I want to make sure, on the release of the G-file material on all critical incidents, I wanna make sure, especially Melanie, when the points that you were bringing out about how a lot of the material in the G-file has to do with things that really have nothing to do with being a police officer. It might be a, you know, somebody who's getting a promotion, or somebody who's about to leave, or somebody, you know, who just has a personal situation going on, and there's complaints going on that really aren't these huge incidents. So we wanted to make sure that y'all heard us about that. But the other side of the release of the G-file on the critical incidents is that when we're doing it regardless of whether or not discipline is rendered, it also, when an officer is cleared of something and it's not released as to why, and the public thinks, oh, they're just covering it up, or they're just doing this or that, it does give the opportunity for not just the public to hear why, but for the officer to actually feel cleared in the public sense of the word. So I just kinda wanted to point that out. So you can move on to 7.
So we have summarized here the officer due process rights going back through this contract. These are all, I think each of these are currently in the labor agreement.
Not the 7.
Except for the 24 hours, which is currently 48, and we're proposing, as our last proposal earlier in this bargaining cycle, we're going to 24 hours notice on the statement to IA. Prior to formal investigation, notified of misconduct, garrity warnings. Prior to the disciplinary review hearing, officer has access to the IA file and the IA summary. Officers can audio tape the file, use holiday vacation, discipline 15 days or less, can appeal if they choose that option. Discipline 16 to 90 days, of course with 143 given up to 15. Only by agreement can we enter into an agreement that allows officers to get a higher level of discipline and stay in their career, so that somebody that makes a serious mistake can be rehabilitated and continue to serve the public. The chief can authorize use of vacation or holiday, but it's not an entitlement there. If there's not an agreed suspension, then the officer can appeal to the Civil Service Commission or independent hearing examiner pursuant to the statute and the contract provisions about this, with reinstatement and back pay options. If you're indefinitely suspended, you may also receive up to 240 hours of accrued vacation and 160 hours of accrued exception vacation. The alternative discipline options also include counseling and rehabilitation services as alternatives to suspension. We believe that these due process rights, along with whatever, as I alluded to, I'm giving y'all an open invitation. If there's something in one of these other labor agreements that you think enhances the fairness and objectivity to officers in this process, we're ready to consider that and take a look at it, because we truly believe, the city manager truly believes, and you know that the chief truly believes, that that is an essential part of what officers are entitled to expect when they come to work here. The challenges of working in a police department in any community in contemporary times is such that for somebody to decide, I'm going to go to Austin, Texas, I'm going to apply, I'm going to go to the academy, and I'm going to be the best police officer that I know how to be there. This is the fair trade, that you are not going to be unfairly disciplined without it being on the basis of the truth and the objective facts. What's our next step? We're going to 16?
Red line 16.
Red line 16.
You guys let us know if you need to break at any point. It's a lot to take in at one time.
Yeah, and what I would like to do, if it's okay, is to cover this one. This is going to be a fairly quick walkthrough, just so that everybody sees what Article 16 looks like with these changes. Let me pause, however, right here, and I'm certainly open to questions, comments on what we've talked about so far. If you feel like we need to do that before I just go through the article itself. Just keep going. Yeah. Good. All right. Thank you, sir. So what you see here is the red line version from existing language out of 16. You'll remember that early in this process, our proposal was essentially to eliminate Article 16. What we have done here is we are keeping the recitation of the purpose in the existing language. that basically just lays out the structure from the original language that we have. We take out the remaining purpose language under B to make sure we don't have inconsistencies with what we are proposing to define with very limited contract language and the companion ordinance. In the subpart there, which is now the new B, the city and the chief of police retain all management rights and authority over the process. So that's just conformed language that's existing. We're proposing to take out Part D there once again to avoid conflicts with the anticipated ordinance provisions, which you'll soon have laying side by side with what we are putting on the table today for the limited contract language. You will see under Section 2 for definitions, what we have done here is to define anonymous complaint, and this adjustment is only to recognize that under current policy and under the newly revised Texas Code of Criminal Procedure, that there are limitations that require public reporting by police officers. And so that's just to make sure that the policy and the law matches with this provision in the labor agreement. B, of course, merely reflects the same adjustment in B. We'll move forward to Section 3. This is the same language, so I'm not going to belabor the red line here, but this is the identical language that you saw earlier about the standalone provision in Section 3. And the former provisions that used to be in that article are proposed as a deletion. When you get to quarterly meetings, we have changed that and added the annual meeting, which you've already seen in the flow chart. Section 4, the civilian panel or board, deletes the language about whether or not it may or may not be created. Deletes the language at the end about the city manager proposing changes and so forth and so on, because that shifts over into the ordinance function and becomes a prerogative of the manager in front of the city council in the ordinance process. And obviously, your association and your members would have the opportunity to be at the table, participate in that process if ordinance changes are taking place. And we believe, in the context of the city manager exercising this authority, that that is a reasonably reliable structure and process that your members can count on. Throughout the state, where police oversight has been done in a different fashion, I think we have seen that happen in a number of other places. And I think that in the city of Austin, there would be a balance in terms of the perspective of yourselves, other city employees, members of the community, and what goes into this ordinance. But obviously, I have to leave that for your internal discussion. We are retaining the training provisions here with the adjustments that have been made there. You see that we have taken out under qualifications, and this is a key change that we've talked about in the past. I do want to emphasize, as Sarah reminds me, that the public feels that it is really important for people that have been through the criminal justice system to have a voice in this process and not to be automatically excluded from participating in a panel. The fact that somebody has previously been indicted, convicted, and so forth should not be a disqualification from being a participant and having a voice about the way citizen oversight should work. Even if somebody was guilty, even if somebody broke the law, even if somebody was punished, that doesn't mean that their perspective on how people should be treated by the police no longer matters. So we have added the think most of what we're doing here is just making sure that the multiple things are covered. We've taken out the different parts of the city language in there to leave that a little less detailed and specific. I don't see there that anything else in this provision probably.
Wait, that's an unintended strikeout.
Yes, I was just gonna talk about
Yeah.
that. The Internal Affairs Division is supposed to be back in. We went over that earlier and restored it, and I'm not sure why it's not in this draft. So attending the 6 hours of training by, actually, it just says attending the prescribed training instead of 6 hours, because it may change. So that's what the next version, the one we send you, will actually have that correction. The rest of the language that you see is just cleanup language until you get to the private panel briefing. That's a correction in the language to Director of OPO, so that's just titling. Under action and recommendations, where you see regarding the following matters. You see recommendations on discipline, review of training practices. Again, I don't think those are substantive changes, I think those are
I
just
think those were
clarifications.
actually accepting some of your language in there.
Okay. And number two under there is struck because that language, that issue or topic will be in the proposed ordinance. Section 5, we have moved independent investigation. It is actually not taken out of the agreement. It's moved down toward the end with no changes, correct?
Correct.
Public release of information. What this language does is to conform the language in this section to what has otherwise been proposed just exactly like the flow chart provided.
So let me, basically, this takes OPO out of this section and leaves it with the CPRP or the Citizen Review Panel. And it leaves OPO in there only as a liaison and an advisor to the panel, but moves all of the other OPO information out of there, but leaves the other intact.
So our labor agreement will continue to structure these aspects of the panel. The OPO is taken out because, once again, it's either dealt with in the limited contract provisions in Section 3 or under the separate ordinance. That explains all of the confirming and conforming contract changes. Section 7 on access to the G files is where we capture the proposed availability of the files.
And that's all the same as current, just
That's
for
what
the
I-
panel.
that's what I was looking for.
The panel.
Panel access only, and no changes from current here in this section. Is that right? I thought there was one
In
adjustment. or
section
change.
7, is that what you're asking?
I thought so, yeah. I guess not. I don't see anything.
No, it's just moved up
It's moved.
because it's
Right.
under the panel only.
Correct.
And it had been more generally under anybody who had
Right.
anything to do with oversight.
Dispute resolution, that paragraph is taken out because, again, those items will be a part of the ordinance. The same thing for the following page where all the language is struck.
That's all. No longer exists.
Independent investigation, you'll see, has been relocated there to the end as section 13. You'll move down to that part. And that's the end of Article 16. So that's just the walkthrough of how we have captured in that article, including section 3 that we started out with, the proposal here. And as soon as possible, as I've indicated, we will be getting you a draft of the ordinance that captures the pieces that have been removed from that prior language.
Before you close that out, Sylvia, will you go back to the top?
The red line 16.
Section one?
It's pretty, I don't know where it's at, but you guys reference CCP and anonymous complaints. And I just
Yes.
want to make sure I wrap my mind around it.
It's on section 2.
So there's two things here. The Code of Criminal Procedure section is the section on chokeholds that they recently enacted. And the other is departmental policy regarding mandatory reporting requirements for officers.
So 21387 is intervention
No,
required?
go back where you were, Sylvia. There, leave it there.
Is,
That's Senate Bill 69.
say again?
Senate Bill 69. Becky?
Do I have the right?
Is it cited wrong?
It could be cited.
Maybe
wrong.
cited wrong.
I don't know. So 21387 that I see talks about my requirement to intervene and stop.
Right, the very bottom of that also has a mandatory reporting.
Yeah, two things.
Yep, I have to report it.
Yes. So what this is saying is that an officer can't make an anonymous complaint under this section if either department policy or that statute would have required them to make a public complaint. And that's all we're looking for.
Okay.
Because we don't have, we don't intend to change the policy, and we don't have the authority to excuse compliance with the law.
Yeah, no. And we see officers failing to use policy to correctly address policy complaints and do things like file anonymous complaints to try to prevent someone from being promoted.
Right, and the manager's position on that specifically is that we don't wanna have one department encouraging another department to violate its own rules.
Sure.
So this will not be encouraging that and having it not considered anonymous.
All good. I appreciate the.
Thanks for asking that question.
Yep.
Yeah.
Yeah. Yeah, this is a load of information. We want to make sure everybody knows what we're not saying.
You have anything right now? Keep pushing.
No, this time.
Okay, so knowing that we have what did we just do? 17,
We have
18, and
20
20,
left.
yeah, so.
Take a break for
Do
a
you
little
wanna
while?
take a break and kind of then make sure you have your questions on this? And we will send you all of this information to visually eyeball it and see, including the chart.
Yeah.
But it's up to you. Ron looks like a football coach.
Leather helmets.
Raise your legs.
No face mask. You good out? Go.
How long will it take to lay out the rest of them?
Much more quickly.
Yeah.
Probably 10 minutes.
Yeah, 15
Well,
minutes.
fine. The question will be, I appreciate you making proposals, and of course we'll get them. Have you set a meeting for next week? I think you're trying.
We have rooms set aside. We actually have our LRO person who checks out the room over there now, and we're looking to set aside Tuesday, Wednesday, Thursday, and Friday.
Okay.
So we will know yet before you leave.
Okay.
Oh, it's a go. Okay.
We now know.
I'm sorry, Sylvia, could you tell us where that is? Do you have the address and
I'll get the physical address and send it out. It's at HRB, actually, the Learning Resource Center off of Burleson.
Okay, so we'll get that and actually announce it, not just send it out so the public can also have that.
Okay, well, just right now, I would think if you lay all of this out, then since it'll give us a chance to review and meet and then be prepared to respond on Tuesday. I don't see how we can give you a response
No, no, I
today.
just meant if
Yeah.
you had any more questions, we might.
No, I'll need to read it, and we'll have to have a discussion, but no, I appreciate it if you just lay it all out.
We can do that.
And then we can
Absolutely.
adjourn from the public side and start working on it, if that's what you want to do.
On yours, 'cause I don't- So, we'll be going over 17, 18, and 20. What we've done, for the most part, in these articles, is to go back through and to make sure that our current proposal reflects the adjustments and changes that we've just gone over with y'all. The first substantive issue on 17 is section 4. I had already referred to the change from 48 hours to 24.
There's a different page, which is that one that we went through in the chart there.
Oh, and Sarah points out that the correction, it's not a correction, it's an adjustment to the prior language which said department, and I alluded to that when we first started with our section 3 language, where I referred to the fact that chapter 143 allows an agent or employee of the municipality to conduct an investigation. That's the definition in the statute. And so we are proposing to go back to that existing definition. Nothing else changes in that section. On section 4, the 24-hour change from the existing 48.
Made a minor change at the end of section 4.
Yes. And that adjustment at the end of section 4, no criminal investigation material that is part of IA can be released to the officer if there's a pending
Look.
criminal
Hang on a second.
investigation.
So it's 4I.
4I.
Sorry, it's not on the screen.
No, go down the other way.
All right.
There.
Yeah.
Let's scroll up.
Right there.
Right there.
You know, since we're looking at different red lines,
Yes, sir.
okay, because I've incorporated all of your prior proposals into a red line version. That's not what up there, so it's just harder for me to tell what
I see
you're
what you're
doing.
saying.
Okay.
Okay.
All right, let's go back and we'll still it on section 1. We'll go back to section 1.
Section 1, B, subparagraph C.
All right. You put 16 back in because you're making a proposal on 16.
That's correct.
All right. I'll get all that, but let me just
Yes.
note for myself in a minute. All right. Then in definitions, you had a different set. You've taken all that out.
Because it came from 16 when we deleted 16, so we brought those definitions from 16 into 17, but since we're putting 16 back in, 17 definitions are essentially going to status quo except for the change in C.
Yeah, your merged contract is kind of a mess because of the way we proposed to eliminate almost all of 16, and we put parts of it in 17.
So did y'all just start a
Yeah,
new, on a clean
yeah.
copy of 17? and
Essentially,
Yeah, so,
yes.
so
That's
we
what
should have
this
explained
is.
that. So from both 16
That's what
and
this is.
17,
Okay.
it's from current contract language
Okay,
because
yeah.
we had deleted and moved
Because you made it a
everything.
mess, he said.
That's right.
Yeah,
Yeah,
we
well,
made it a
Although
mess.
Bull implied that it was Ron's.
I'll have the
mess.
record reflect. You can read mine and see what's going on.
Yeah.
Okay.
But
I don't
yeah,
even,
so
I
it's
don't
from-
even.
It doesn't
dis- I
require-
don't even dispute that.
It doesn't require a mystery to figure out what's
Right,
changed.
right.
All right, I'll look at it and, yeah, I'm just
But
making.
you were
just-
opposed to us eliminating 16, and so now we're being
No, I have
nice
no
and
I have
putting
no
it back.
problem with that. I'm just trying, I'll look at it and compare, I'm just trying to get it conceptually. So in 3,
Mhm.
going down to, up just a little bit. You put back in all that language, for this provision has no application to code.
Yes,
Could you scroll down?
Go down. All right, there you go. So you struck this provision all the way down to code. Are you putting all of that back in the contract?
Hang on.
Yes.
Yes.
And Becky? Is that missing a part as well?
I don't, I'll have to look, but that's gonna,
That I
just
added
on the
in there?
surface, looks like a lot of conflicts with what you're proposing.
I don't think so.
Well, it is because there,
Okay,
let us
we'll look at
redraft
our
that
final
section.
draft, yeah.
So, you're striking it or not striking it? You don't know?
No, I know that we're not striking it, but it should have after the word,
I don't see any change.
no, but there should be a subject to, you know, so the compelled testimony is there. Let us re-give you that particular section.
Okay, all right, well, I'll go to 4A, I understand your position there. And then in B, you're putting all that back into place, the current language?
Correct.
All right, just a second here. Okay, so. All right, so now B, and what would be C, if you go up just a little bit, there you go. You're putting the current language back in and
Yes.
taking out your changes?
Yes.
Okay. Then in, what would be F, yearly, okay, I see, I got that. All right. If you'll go down to 5, and I think it's just, if I can just get a grip and then I'll just know what you're doing. All right. Well, go up just a little bit. 4I.
4I.
You
This
didn't
is
have
new.
any changes previously. You're putting new language in?
That's
This is
correct.
new, yes.
This is just clarification language because it wasn't clear if release meant release to the public or, and what that meant is to the officer, so we were just trying to.
Okay,
Yeah.
I'm just coloring it so I know there'll be
Brand
some
new.
language
Brand
coming
new.
for that.
Sure.
So this is the one where there's, you know, CID or some other criminal investigation division has a file, that's not available.
Okay. And in 5, we got some, you had just some changes over, what is it called, pronouns that you had in there.
Right.
And then in A, and in B, okay, of course, you're, just a second, I won't. Yeah, we had added this.
You had added sworn, and we
Yeah,
we
yeah.
were rejecting
So
sworn.
I will tell you honestly, at the end of the day, on this one, we don't care whether it reads sworn or not, because the only thing that this paragraph is that the officer may audio tape it. So if you don't want him audio taping the portion where the OPO is discussing it, you know, that's fine with us, but we just didn't think that made sense.
Okay, so is 6 what you had before?
No, this is changed to now, prior, we asked for release of all G-file information. This has been limited to just critical incidents that Lowell went over.
Okay, well, okay, I'll know to.
Yeah, and it
I'll
structures
proof
it before,
that.
during, and after, kind of like we had before.
Yes.
All right, go down just a little bit.
Yeah, so we don't have an argument about the effective date and what the impact is.
Yeah, I'm just noting that I'll take what you have and know that I need to look at that to kind of progress. So, keep going. There you go. And hold on a second.
That's
And this
new.
is critical.
That's new.
No. Is it intended to ensure confidentiality or e-ensure?
I am happy for that to read with an E. I
Ensure.
thought that was nitpicking at this point because we were making so many changes.
You know, I get,
I'm a big
I think EN,
proponent
SUR.
of
It
EN.
should be a EN.
it's
Yeah.
I had to go look at it. I was
There was-
Beowulf, I remember, but that's.
There was a period of time
From
where, colloquially, I was appropriate.
I know,
and not-
I know, I just,
I never bought off on
Right.
that either, so
All right.
we're happy to have
And
that. as a-
Xanadu did Kubla Khan, a stately pleasure dome.
Love you,
free.
Trey.
He brought up Beowulf.
I know.
and you learned that there at Refugio High School? All right, you made a little change in A. Your prior was state and federal law, and you struck 143. You left 143 and put disagreement. It's okay. I'll correct it. All right, if you'll go down to 7.
What was that footnote?
Huh?
What was the footnote we just wrote?
We're trying to track what we're doing,
Got it.
so, yeah.
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 I'll look at the hard copy and put together. All right. If you'll go to 8. All right, you got some new language in 8.
That's just clarification. It didn't make sense. It would have been contradictory without it. It just didn't really make sense the way it wrote before.
Oh, that's okay. All right. And 9. So, all right. Okay, I understand. So when I look at your copy, I can look at it.
Okay, and we will give you a clarified section 3.
All right. You want to put up your 18 so I can just kind of see. Is there any changes in 18?
There are a number of changes, many of them are cleanup language.
There are no changes in 18.
Oh, from the last one? Okay, so all these are the same as our last proposal?
I believe so.
Oh.
You want to just roll through it and I'll look up there
Yep.
and just imagine it red and blue?
Yep.
All right. I don't see anything in section 1 till you get to B. Yeah, some pronouns, okay.
Scroll down a little more, so, yeah.
Pronouns and calendar days.
Yeah, okay.
I think we should have
I
given.
didn't see anything in C.
Did you spot something new, Becky?
No, just, we may have provided responses as to our acceptance of calendar days here
Oh,
and there,
okay.
just, you know.
I'll look at it.
Yeah.
All right, in section 2, see anything? 3.
Same.
Just
Yeah,
calendar
I'm not,
days.
I'll fix, calendars and so on.
Scroll down, so.
Keep going. 5, 6.
5, 6 calendar
7.
days.
Let's get to 8.
Yeah.
Nothing in 7.
All right, is this your prior proposal?
There's a little bit of just tweaking, clarification, but it's essentially.
Substantively, this is exactly the
Exactly.
same as our prior
Yeah.
proposal. There's some cleanup differences. We'll study it and you do the same.
All right, thank you. All right, if you'll go 9, 10, 11, 12,
12's calendar days.
13, there's just some
Calendar
pronouns
days.
and stuff, calendars.
Right.
So.
Pronouns in 13.
And let's go down to 16.
So, in our prior 18, we had added a whole new section because of our deletion of 16. So that's gone now.
And this is back to current language.
So it's back to current language.
So, yeah, the access to IAD files that you struck and put notice, go on down just a little bit, if you would. Keep
'Cause-
going.
Section
All right, right there. In 19, you struck it, and then you created a new 19 under notice. Are you putting the old 19 back?
We're putting the old 19
Putting
back.
the old back.
And-
Yeah.
And you go up just a little bit. No, I'm sorry, down. Keep going. All right,
That's
so
it.
all of 19, that noticed officer is gone.
Yeah, so you see, we had deleted it in 413, and we put it back to status
And
quo.
this one is back.
Yeah.
Okay.
Deleting 16 did kind of create some, putting either 17 or 18, we're trying to put that back.
Okay.
Will you go back up, sir? I don't know. I feel like Becky was gonna say something and I thought something and.
I recorded every word.
Well, you scroll down slowly from there.
Up or down?
Down. So it's briefs.
There were no changes.
Special appeals for promotion. Oh, this is a question I had. in 16, it looks like we struck mediation. Is that accurate?
You mean our proposal?
No. I
No,
said
they
we.
never.
In 16, yes.
That's correct.
Yes.
What's the big picture idea?
Big picture idea is that OPO works for the city manager, and
Well, I think we're talking about two different things, I'm sorry.
He shifted to Article 16.
You're back to 16, because this is 18 mediation.
I know, but it triggered my memory, and if I don't ask it now, I'll forget.
yeah, so that was basically mediation over the OPO's conduct, and this is
Okay.
mediation
Yeah,
over
yeah, it's a
the.
different.
Just right.
Yeah, all right. All right. If you will go to 18, perhaps, did you make substantive changes there?
Oh,
That's what
20?
we just- that's what
You
we
mean
just went
20?
through.
Oh, I'm sorry,
You mean
I got
20?
it broken out in separate deals. All right, let's go to
20 is the
20.
next one.
20, there should be no changes from our last
No
proposal.
substantive changes, no changes
No
at all?
changes at
No
all.
changes at
None.
all.
All right,
Let me go.
I'm not gonna talk about that.
Well, I'll restate the obvious, just for the record.
Okay.
It'd be a hard argument to convince us to allow the city to take an arbitration process to determine what the parties meant by agreement. And every time the city disagrees, they can spend taxpayer money appealing and tying that up. The law already sets out a pretty clear burden. It's heavy for both sides to go to a court over an agreed arbitration. And you have the limits of fraud, collusion, exceeds jurisdiction, basically. So we have a lot of heartburn just saying, if you don't like the case, you can take it to court. We got out of that in the 1980s when we worked out arbitration in the disciplinary process. And I understand what you want. I'm just telling you, it's gonna be a steep argument for us because we're willing to live with them, win or lose.
And let me respond to that and make sure that we truly understand what we're asking for here. Because I want to understand what you're saying exactly. We had a discussion this morning in our caucus that we haven't finished yet, looking at what the current status of the case law has been in these disciplinary cases that the Supreme Court has taken a look at, the courts of appeals have taken a look at. So we are still studying that. We can complete this particular conversation soon. I don't think you have a problem with sub 1 or sub 2, because I think those are exactly what you just referred to, which is if the arbitrator exceeds their authority, that's the common law standard.
Yes.
That's been there all along. Number 2, that the decision was procured by fraud, collusion, or unlawful means. So we're not really talking about those, we're just talking about 3, right?
Correct.
Okay. And so our perspective on 3 is not that every case gets appealed. I understand the position or the anxiety, concern, whatever it may be, that the point of these things is they are alternatives to litigation. They are supposed to be final almost every time. I believe that number 3 is also a high standard, a high burden of proof, and we recognize that it is not often going to have any success. I believe that it is clear that a manifest error of law is already a part of the common law standard. That's what happened in Kelly versus Waco, where the Supreme Court said the statute doesn't let you do that, and so you can't do it.
And it's in the current contract.
And so the factual piece, that last word, a clear and manifest error of fact, is the only thing that's left.
That's correct.
And we are certainly willing to talk about that. We don't feel differently that this should be final almost every time.
I believe that it ought to be final, except with a heavy burden. Otherwise, the courts do not want to have administrative cases.
Right.
Otherwise, I didn't get my barber license. Next thing you know, I'm down at the district court.
I don't
my
think we
plumbing
disagree.
license. So
I don't think we disagree.
We have
I wanna make
hundreds of years, well, not hundred, but a long term of arbitration, and we have it in statutorily at least almost 50 years in contract.
Right.
So if nobody else has placed this burden on appeals, why would we want a path where taxpayer money is unlimited, what you can spend? Waco proved that. The city was going to spend $500,000 to not put a guy back. So That's what our concern is, and I understand your position.
All right. And I understand yours, and I just want to make sure we work to fully understand the scope, because I think I have a much smaller ask than what you have described.
And just, we're clear, these are contract disputes. This is not disciplinary arbitration. These are disputes between the parties as to what we put on paper. And there will be disagreements.
That's good.
Otherwise, we'd copy the one perfect contract.
No,
and have to do it.
absolutely.
So we understand, the words, the
Absolutely.
parties have disagreements. And we're accepting of that, and we're fortunate here. I don't think, this isn't, I won't name another city of which, Rebecca, you've worked in, where our grievances have come by the hundreds.
Right.
That's not true here, so. All right.
Well, and you make a good point, Ron, that I've alluded to some case law out of the disciplinary side, but this is not the disciplinary
No.
issue. This is the contract grievance arbitration.
That's correct.
Some of those principles, I think, work in both environments, but that's all we're talking about.
Okay, I understand your position.
I would like to point out that when Ron says I have a problem, that he's speaking on behalf of the association.
Yes, indeed.
You're welcome to jump in
Thank
there.
you.
Yes,
The Royal
indeed.
we.
The Royal League.
Right.
All right. Anything else?
We, myself, and I.
That's right.
Yeah. All right.
Yeah,
Thank
with-
y'all for
with-
your patience.
Yeah, with the exception of Article 17, Section 3,
We're gonna email you
We'll fix that.
the final stuff, yeah.
All right, and so, just so the public doesn't wait, we don't intend to come back today unless you just think that's necessary, because I don't,
well, I would like to announce, do we have the room number?
Yes.
Okay, yeah, so if she can just announce
Yeah.
we're posting the meetings for next week.
yeah.
So the address is 5202 East Benoit, Suite 500. Room assignments are auditorium room 204, that's gonna be for the public. APA will be in training room 239 A and B. And the city will be in 244.
And I'll send that to you guys, of course.
The address is 5202 East Benoit, Suite 500. And can you give us the dates again?
Where's that at?
That is, October 25th, 26th, 27th, and 28th.
Oh, yeah. Alvin
Tuesday,
Devane.
Wednesday, Thursday, and Friday.
If only the police department could get a nice little piece of land like that.
Or else.
That's on the old home stomping ground, isn't it?
Okay, so that should be.
All right. We appreciate your
All those
time.
weeks, except for Monday,
It will
'cause I'm going
also
on the
be on our website tonight.
Okay, excellent.
Go to Madison this weekend.
Sixth.